is a community education production brought to you by the Bar Association of Montgomery County and the Montgomery County, Maryland Bar Foundation. The program is designed to provide you with general information regarding your rights and obligations under the law. It is not intended as specific legal advice. You should discuss the facts and circumstances of any particular matter with your own attorney and obtain advice specific to your case. The participants are local attorneys who have volunteered their time to bring you this program. We hope you find it informative and beneficial.
I'm David Watkin, an attorney in Montgomery County, Maryland. On this edition of Law School for the Public, we will explore what happens when you go to court, you win your case, the judge rules that someone owes you money, but that person doesn't pay. How do you turn a judgment, basically a white piece of paper from the court, into green? The process of collecting a judgment for a creditor, that is someone who is owed money, can be complicated, time-consuming, frustrating, and expensive. On the flip side, what if you are the person that the court says owes the money, that is the debtor? What if the court made a mistake, you didn't know about the case, or you simply don't have the money? What options do you have to protect your rights and your property? To help us understand the law in this area from the perspective of both creditors and debtors, we are joined by attorney Mary Ellen Flynn of Andelman & Flynn in Silver Spring, Maryland. Mary Ellen has substantial experience representing creditors in debt collection as well as teaching on the subject. Her practice also focuses on domestic relations law and civil litigation. She is a former president of the Bar Association of Montgomery County. We are also joined by Anthony Davis, the Director of Advocacy for Consumer Law at Maryland Legal Aid. Anthony manages the Foreclosure Legal Assistance Project, along with other statewide initiatives involving the rights of debtors and homeowners. Anthony helps debtors defend themselves against creditors. Anthony, Mary Ellen, thank you both for joining us today.
It's a pleasure.
You're welcome.
Mary Ellen, let's start with you. What exactly is a judgment?
A judgment is an award from the court to one person. If it's a monetary judgment, then it's an award of money against one individual in favor of another individual.
And how is that different from like an order, let's say?
Maybe in family law cases, you would have an order to pay someone, like maybe child support or spousal support. That order to pay money, you can't like do garnishments or other post-judgment type of activities until that order to pay is reduced to a judgment.
Okay, and so suppose someone owes me money, you represent me in court, the court says they have to pay me the money, you get the judgment, then what? How do I get the money?
Okay, you get the judgment, it's in your favor.
Right.
So you then have the right to do various what we call post-judgment activities. You could do a writ of garnishment on wages, maybe a garnishment of money that's in a bank account.
What is a garnishment, by the way?
Okay, a garnishment is the right to essentially seize money.
Okay.
And when you're doing a garnishment on wages, you serve that on the debtor's employer.
Okay.
And that employer then has to pay, and there's a percentage set forth in the law, they have to then automatically pay that percentage to the creditor every time that the debtor gets paid, a percentage then goes to the creditor. If you did a garnishment on a bank account, that only works on the money that's in that bank account at the time that the garnishment is served. Once the bank says we have so much money of the debtor, the creditor then has to file something to actually get that money from the bank. And then once that's done, the garnishment is over. If the debtor puts more money in the bank account, it doesn't automatically go to the creditor. The creditor would then have to do another bank garnishment.
And sometimes you hear the word attachment in the context of collection. What is that?
Sure, a garnishment is a form of attachment. It's that would be attachment like of wages or attachment of money in a bank account. You could also do an attachment through MVA, which is a lien on an automobile. You can also attach a person's interest in a business or perhaps in real property in a house.
Okay, and Anthony, you tend to be on the debtor side of these matters.
Yes, I do.
What happens if, let's say I find out someone's got a judgment against me for $10,000 or whatever it is, and I'm really worried about that, and I come to you and say, do I have to pay that? What am I supposed to do?
Well, if listening to your question, if you found out that you had a judgment against you, certain things have happened already. The biggest thing being that someone sued you, presumably sent you notice, and you did not respond. When you're being sued, a letter comes to you in the mail, or summons comes to you in the mail, and there's a detachable piece of paper at the bottom. It's a notice of intent to defend. You would send that in.
This is in the district court.
In the district court, yes, in the district court. You would send that, fill that out, say that you would intend to come to court. If you found out a judgment happened against you, you didn't do that. So first thing would do, did you owe the debt? If you didn't owe the debt, you can have the option of moving to vacate that. You'd file a motion to vacate the judgment. You'd have to explain why you weren't in court, but that's the first option to do, because the judgment would be a default judgment. If you simply can't pay, I have a judgment, I don't dispute I owe the money, but I just don't have the money at all.
Or I don't want to pay.
Or you don't want to pay. Well,
We had a dispute, and the judge said that I have to pay them $10,000, and I don't really think I owe. I think the judge was wrong. I don't want to pay him $10,000.
Then you would probably want to appeal.
Yeah.
You want to appeal what happened, the decision that happened to the judge. You'd have to give reasons for the appeal, not just I don't want to pay. And hopefully with that appeal, you'll get maybe you'll get a favorable ruling, and you don't have to pay. In the event that it sticks, your options do become limited. Bankruptcy is always a catch-all that people talk about. Bankruptcy is the actual discharging of your debts, and that is an option for people, but it would be the last option.
All right, well, let's roll that back a little bit. So if for example, I came to you and said, I think the court made a mistake and I shouldn't have to pay this money, and you say, we can do an appeal. Do I then not have to pay the money if we seek an appeal?
If you want to do an appeal, I do believe, and please correct me for fill in, you would have to submit a percentage of the judgment amount. So if your judgment amount is $10,000, I do believe that you would have to submit some amount, post a bond, or which would probably require 10% of the amount. A bond company would pay the difference, and then you would submit your appeal to the court. Again, what you're looking for, you want to be successful, so you want to have more reasonings than I didn't like the judge's decision, because if you're not successful, then you're going to lose that money, the bond is going to be paid, then you're going to have another problem because the bondsman is going to come after you.
All right, well, there's some other scenarios.
Okay.
I may have some other reasons, but before we get to that, Mary Ellen, switching my hat, I'm now your client, and we got this case and we won, and this guy's saying that he thinks the judge made a mistake and he's going to appeal. And I said to you, they've owed me this money for a long time. This is just another one of their games. I mean, do we really now not get the money because they're filing an appeal? How does that work from my perspective, the creditor?
Right. Well, when the debtor files an appeal, the creditor still has the right to try to collect on the judgment unless a bond is posted, as Anthony said.
Okay.
But many times people don't realize that. They think they appealed and then the creditor can't do anything. So that is why then the debtor would file, get a bond so that this way they could stay execution of the judgment. I would encourage debtors to certainly reach out to the creditor or the creditor's attorney and see maybe, even though there's a judgment, a payment plan might be possible. And many times what I do on behalf of my clients, the creditors, is go into agreements called stay on execution of judgment. And what that does is we work out a payment plan, and as long as the debtor honors the payment plan, then I stop any type of garnishment or other post-judgment activities.
Okay, so it's basically as long as they keep paying, then you're not going to go after their assets?
If we work out an agreement and they're paying according to the payment plan, yes. And I would want to point out it's important to appeal. You really need to appeal within 30 days of the judgment, because that's the only time you have to appeal a judgment.
Okay, and so Anthony, coming back to something we had touched on briefly before, the client comes to you and says, you know, I got this judgment in the mail. This is the first I'm ever hearing about it. I never got any paperwork from the court. What can I do in that situation?
Well, again, we always want to encourage you to stay in contact with the creditors. If you get a situation where you didn't know about the judgment, the court proceeding, you can file, again, the motion to vacate the judgment. What you're trying to do is to get the judgment, to get back into court, to get the judgment vacated, removed or dismissed, and go back and present any defenses that you may have. What Mary Ellen said that, you know, we encouraged the debtors to stay in contact with the creditors to try to work out something. What debtors don't realize is that the creditors want to work out a deal with you. And that usually happens before you even get to a point of going to court. They usually send some correspondence. When people tell me that I didn't get any correspondence, there's usually a paper trail that happens and that follows, and it costs money for a creditor who's already trying to collect money to then spend money on an attorney and a court process. They want to work out some deal. But I find that debtors are reluctant because they don't know what's going to happen. If they don't feel that they have a defense to the debt, it's like, why should I go anyway? Because I can't change anything. But you want to stay involved. You don't want a surprise. What you don't want is one day you go get your paycheck and 25% of the paycheck has been garnished for you. You don't want to go to your bank account and find out that as you're trying to pay your rent or your car payment, that the bank account is frozen and all of your money is in that account. So it is imperative that you go to court, that you stay involved in the process. If a judgment came and you didn't know about it, seek legal advice. Go to the court, file a motion to vacate the judgment, submit your reasons why. If you get back in the court, again, you have another chance to defend or to arrange a payment plan that will make it, at least you know what's happening and there's no surprises in that situation.
Now, Mary Ellen, sometimes you hear about confessed judgments. What exactly are they?
Confessed judgments is, it's an agreement. First, the way a confessed judgment happens is someone entered into an agreement, and it says that if a person doesn't pay pursuant to whatever that agreement is,
Let's say it's a loan, for example.
a loan, and they default on the loan, and then there would be a provision in that agreement that says upon default, confessed judgment would be entered against you. What that means is the creditor then files in court a complaint for confessed judgment. And then what happens is judgment is then entered against the debtor, and then the debtor has the burden of proving why that confessed judgment is not appropriate. The benefit of that to a creditor is upon filing for it, you get a judgment right away. You don't have to go through trial.
Do you have to serve the debtor?
Yes, you do. Yes, you have to serve them, and they have the notice, and then the notice will tell them that they have 30 days to contest the confessed judgment. In that case, you absolutely don't want to ignore that notice.
And all this information is contained in the notices that you would receive. So a debtor or who receives this information, if you think like, well, I don't know what to do, the information is available to you. The time details are in there, and it is imperative that you act quickly, before you lose your rights.
But a lot of times it's legally, if you're not a lawyer, you don't know what a garnishment is, you don't know what confessed judgment, you may not even know what a judgment is. And what do you do? I guess you come to your office.
I was going to do a shameless plug for Maryland Legal Aid because we do offer advice in civil proceedings. There are income requirements. But if you did, there are a lot of pro bono agencies. There's a lot of resources that you can use. You can even go to the court, a district court or circuit court. And I do find that the publications that are available, they are free publications. How to defend against a debt, how to even start a wage garnishment or a lien. That information is available, and it's not in legalese, it's in layman's terms, and it's been very useful to my clients. I always point them in that direction as well.
And you can get that at the courthouse? Or
you can get those at the clerk of court's offices, and if you go online, I do believe these same publications are available online at district courts of Maryland and circuit courts as well. I'm pretty sure they are.
The one player we haven't talked about, maybe we should touch on briefly, is the employer who gets the garnishment order for one of his employees who is the debtor. What obligations does the employer have? The employer likes the debtor. He's a good employee. He's trying to help him out if he can. He feels bad for him. It has nothing to do with the employment. What, if any, obligations does the employer have when they receive that garnishment order?
The employer absolutely wants to read that notice. Read the writ of garnishment.
Seems as a general rule we should read stuff.
Yes,
and
make
comply.
sure you read it, and it's very clear what you do. What you have to do is you fill out there's blanks right on the form, whether it's district court writ of garnishment of wages or a circuit court writ of garnishment of wages, and you fill in the information of what is the person's gross salary, what is their deductions, mandatory deductions, and insurance does count as a deduction that you can take out. How often is the person paid? If the employer ignores the writ of garnishment on wages, and that has happened in some of my cases, sometimes I think maybe it's someone's best friend or family member, and they're thinking, well, maybe if I just ignore this, they'll go away. We, the creditor, then has the right to get an actual judgment against the employer for ignoring that writ of garnishment on wages.
So they could be on the hook for the full amount?
They could be, yes.
And attorney's fees?
I don't know if attorney's fees is included. I don't think so for not complying with a writ of garnishment on wages on the employer side.
So they probably don't like the employee that much to assume the debt for them. I also wanted to say, since we were talking about if you, as an individual, are a creditor, if you are successful in getting a wage attachment, a garnishment against them, you have to send the statements. Every time you receive money, you should have to keep an accounting of the monies that you receive and provide statements as well to the garnished individual.
To the debtor.
Yes.
Now, what happens, Anthony, if you have a situation where the person went through the process, they lost in court, they don't want to appeal, but it's really more money than they can afford to pay. They may have some, maybe they have a home and maybe they own a car and some other things, but they don't, let's say it's a judgment for $50,000 and they don't have $50,000 in cash or anywhere close to that. What are their options? What can they do?
Well, again, the situation happens a great deal because, especially in my line of work, most people are just barely enough to get by, and that's probably what led to the judgment in the first place. Your options do become limited. There's no ifs, ands, or buts about that. A judgment against you can attach to your home if you have a home. It can, again, garnish your wages. It can freeze your bank accounts. If you can't pay, I would still urge, even if you think that it's just too much money, I would still urge you to first contact the creditor and try to work out some arrangement. Explain your situation and see what you can do, because the creditor does have rights. A debtor with judgment against them, that's not only one side of the story. A creditor does have rights, and they do have a right to enforce their judgment and to try to get those monies from you. Bankruptcy, again, can be an option if you just can't make it, but it comes with there's other ramifications to bankruptcy, and that's really the last resort.
Subject for another show.
Yes, but some people can't. They can't have a lien against their property, can't have a wage garnishment, can't risk getting their bank accounts frozen, and maybe they just can't work out a payment plan that's suitable for all parties involved. Again, that's when bankruptcy may be the option to help you keep your head above water.
Now, what if you have a client who comes to you who says, Anthony, I have this idea. I have a cousin in Virginia. I have an uncle in Kansas. I'm gonna send them a bunch of my. I have a rare coin collection that's worth a lot of money. I have some cash. I'm gonna start giving this out to people, so Mary Ellen won't be able to get her hands on it. Is that a good strategy?
That is not a good strategy, and you're walking the fine line between fraud and such. I would not recommend that as well. You don't want to be in a situation where you're trying to hide assets and stuff. You do have some protections through exemptions in the state of Maryland, but again, the best bet and the best course of action would be to try to work out some type of assistance, some type of plan. I would not suggest, if you're found out and these things do come to light, it'll make the situation that much worse for you, even worse for you.
And do you ever come across that where somebody tries to hide their assets or anything?
I do. A common, not that common, but we see it sometimes, is where perhaps someone transferred interest that they have in a house to someone else, typically a relative. What we do on behalf of our clients is we actually look at that transaction. Who did they transfer the house to? How much was paid for that interest in the house? Was it really an arm's length transaction? If none of that is true, then what we do is it's called a motion to void a fraudulent transfer. And we actually then are able to undo that transfer and put that property back into the debtor's name. And then we can collect against it.
Now, what happens if it's a situation where they liquidate the interest? Let's say it's a car and they transfer ownership of the car to their uncle, and then the uncle goes out and sells the car. What?
I think then the creditor is not going to be able to, once that asset is gone, there's nothing to seize from it.
Okay. Is that a good strategy? Sell the car?
No, the creditor isn't satisfied, but still, the judgment still remains.
Is there a way to make yourself judgment proof as a debtor?
Judgment proof is really not a situation you want to be in, because judgment proof means you have no assets, most particularly a home is what we're looking at, no bank accounts, no job. Okay, so a creditor's options to collect are limited at that point in time, but again, the judgment is still there. The judgment is 12 years. It can be renewed again and again, so the judgment can continue to last. And if you do become employed, if you do own a home, it's a situation where if you want to improve, it's always going to be there. Again, judgment proof may be for the limited time, but in the long run, it's not a place where you want to stay and be.
No, not a long-term strategy.
No, not at all. Not to get away from
You mentioned exemptions before. Is there certain property that the Mary Ellens of the world can't go after in Maryland?
Yes, there are certain, and I'm not well versed in all of them. I only know the exemptions from the bankruptcy standpoint, but certainly Social Security.
Yes, Social Security income, disability income is not garnishable. Also, there's a $6,000 personal exemption. So if you have, up to $6,000 sitting in a bank account, you want to exempt that. And this is another instance where it pays to read the form. If you receive a writ of garnishment on a bank account, read the back of the form, and right there on the back of the form will tell you the exemptions that you can, take advantage of.
Now, it sounds like this could be, if you have a difficult debtor who's trying to make your life difficult, it could be a time-consuming and costly process. Is there, at the end of the day, is the creditor able to recover the costs of collection? Is that part of the judgment?
Yes, yes. When you get your initial judgment, you're entitled to whatever you paid in your filing fee and process serving fee. That's someone who served the complaint on the debtor.
Okay.
Then as you're doing course of collections, every time you do a writ of garnishment, that costs money. And then you can always add those costs that you keep incurring, and they have to be court costs. Then they can get added to the judgment.
What about attorney's fees?
Attorney's fees, you have to be awarded, the creditor has to be awarded them at the time of the judgment. And that's another reason why the debtor might want to avoid a judgment being entered against them. Because if the creditor is entitled to attorney's fees, those attorney's fees don't become a judgment against the debtor until it goes to court and a judge awards it. Interest is also another benefit to a creditor getting a judgment, because unless there's special circumstances, your judgments continue to accrue interest at the rate of 10% per year.
Wow, that's a lot of money.
It really does add up. So that's another reason why you'd want to work something out with the creditor.
And we only have about a minute, but what if you don't know what assets the debtor has? Or you kind of alluded to it, I think, toward the beginning of the show about being able to get information.
Right. Once you have a judgment against someone, then as a creditor, you're entitled to do post-judgment interrogatories where you send questions and the debtor answers those questions. What I find to be more effective is requesting an oral exam. And what that is you compel the debtor to come to court and answer questions about their assets. And questions can be, where is it that you're working? How much money do you earn? What property do you have? What bank accounts you have? And as part of that process, the creditor also has the right to ask for documents, such as show me your last 3 years of tax returns, your bank account statements, and your pay stub.
Well, unfortunately, we are out of time. Anthony Davis, Mary Ellen Flynn, thank you so much for coming here today and helping us understand the law of collecting a judgment.
Thank you.
Thank you.
Please let us know what you think, as well as what topics you'd like to see on future programs by emailing us at lawschoolforthepublic@gmail.com, or feel free to email me directly at david@wakenlaw.com. On behalf of the Montgomery County Bar Foundation, I'm David Waken. Thank you for joining us.